decision making, even counterproductive to their own stated goals, and understand those and understand how human beings come to be in the grips of these moral panics. They seem to happen over and over again in history. We seem to fall prey to them over and over again. So study those, think about those. Think about when am I in similar situations, what can I do to get out of them? One of the important things is the one John talked about, which is don't have a super insular decision-making process and be open to considering thoughts from people who may not agree with you. Next, I would urge you to reject crude views, crude versions of legal instrumentalism. When I went to law school in the mid-'80s, the progressive lefty professors, would say to me, John, if you think that the law has any content other than personal preference in politics, you're either being naive or in bad faith. I used to hear that a lot from the progressive left professors, not all of them. And yet then we find there are times, hey, we want to hold people to the rule of law. The rule of law matters, taking law seriously, that it's got some independent content, that the law might require something I don't necessarily like politically. So at least ask yourself, do you want to take a crudely instrumental view of law, or do you want to put a little faith on this hoary old concept of the rule of law that matters? I would urge you to seriously consider the latter over the former. Next, understand that moral judgment is part of what a lawyer contributes. It's part of your value add. Just pure technical legal advice, there's some times when that's all a client needs or someone needs. But bear in mind, the law never strays far from morality one way or the other. So understand that that's something you can bring to bear, and the ethics rules say you may do so. They don't say you have to, but you're allowed to bring some morality and social context to your legal ethics advice to everyone, even if you take a client-centered view. Those are my few comments.
Thanks. So we're going to take some Q&A from the audience, but first I have a question for the audience. Well, actually, it's a request. We are holding a lot of programming for Ending Torture Month, and plan to have another month next semester. This involves flying in experts from DC and housing them, and also hosting lots of receptions so that we can build community and dialogue around these issues together. So my request is we're going to pass 2 shoe boxes, and my request is for donations. If everyone in this room gave just $1, we'd raise, I don't know, maybe 200, 150. That would really help. That would pay for at least one reception. But I know a lot of you could give more. So if you can give $1, $5, or $50, we will use it on speakers, flights, housing, and reception.
If I could say, Kathleen Clark is coming out, Washington University of St. Louis. She is the top academic and thinker on the legal ethics of government lawyers. And if you find that at all interesting, I'd love to hear her talk. She'll be out.
Yeah, and that's going to be next week, next Thursday. Yeah, at lunchtime. And we're paying for that. So thank you for anything that you can give. And hands please for questions. And Rachel will be able to bring the mic over. Okay, I'm going to take in the back in the blue shirt. You're looking behind you. Yes, you.
Is there any way to get judicial review of this memo, or if the case can never get there because the lawyers are maybe just lawyers and the people who are following the memos were just doing as they were told, then you could never find out what no court could then say this is illegal or whatever.
I think there are at least 3 ways that there could be judicial review of the matter. Number 1, there could be a criminal case. Right? I'm not saying that it's impossible. I'm saying that it would be a difficult matter, right, in view of the common law, in view of the defenses that would be available to the defendants and the legal standards that would apply. But a prosecution, it's not prohibited to bring one. I just think it's a tough case. You could have, as John mentioned, a civil case, and we have one going on in the Northern District of California right now. The third thing is you can have either criminal, more likely criminal, or possibly civil review in a foreign court. And so the possibility of indictment under foreign courts exercising universal jurisdiction over the torture statute is another possibility. I think there actually has been, in fact, an investigation opened up maybe in Spain. I'd have to check my notes on this. So there are at least 3 possibilities. I think each of them are fraught with difficulty, and there's no guarantee that any of them would ever reach an outcome, but there are at least theoretically avenues.
And the disciplinary possibility.
that would be also a judicial review, or that would be the state bar?
Well, I mean, a bar discipline ultimately ends up in court because lawyers are admitted to practice by a court and then ultimately are subject to losing their status. So in California, it's ultimately the California Supreme Court that would, if it were a California matter, as John said, it's really Pennsylvania.
Broadly, you might think of professional discipline as a quasi-criminal court that sits halfway between a civil liability court or a full criminal court.
Oh, and I would add that actually this really expansive view of executive powers in time of war has been rejected, not in a torture case, but in Hamdan, which challenged the use of executive military commissions. So the Supreme Court of the United States has really rejected that theory pretty clearly, I think. So at least that portion of the memos, with the sort of broad expansiveness of it, has been rejected in U.S. law. Yes, in the blue shirt there. Yeah. Do you need the mic? You can speak up.
I'm fine.
Okay.
A couple of points, a couple of questions that I want to ask Professor Weiner regarding points that he made. The first was that several of the processes used by the interrogators, walling, slapping, dousing with cold water, sleep deprivation. You said that individually these might not constitute torture. What about collectively? How many slaps is too many? If you slap a detainee once, you may not be committing torture. If you slap him 50 times, are you? And is that a question? Is that a question that you think ought to be addressed?
I mean, the answer is yes. Right? Obviously, the aggregation of acts that by themselves don't constitute torture collectively can create a pattern of practice. If you look at some of the U.S. cases that have been brought under the Torture Victims Protective Act, you often have an aggregation of acts: severe beatings plus, electroshock plus threats of death. Right. So clearly, you want to look at the series of events as a whole. But the point is that the series of acts as a whole still has to meet the standard of inflicting severe pain and suffering. Right. So you don't add them up. And when you reach a magic number, I mean, you have to look at the entire transaction, course of conduct, to figure out whether it meets the standard. Now, in fact, if you look at the memos that were released in April of 2009, the Justice Department did just that. They were originally asked whether each of these acts constituted torture, and they opined that they didn't. And then the operators came back and said, well, what if we do them together, right? And the OLC opined on that. But that clearly is a relevant consideration.
My second question
is... If that's okay, we're going to give other folks a chance, and then we'll get back to you for the next two. All right?
Can I have one comment on that?
Sure.
Because the one exhaustive example that we can look at to see about aggregation techniques was not at the black sites, but down at Guantanamo. The guy was thought to be the 20th hijacker, Mohammed al-Qahtani, and there was an exhaustive log of everything that was done to him. So basically, for 60 days, he was subjected to extreme sleep deprivation, malnutrition, all kinds of environmental manipulation. And, I think that whole, Philippe Sands in his book, Torture Team, goes all the way through that. And I think it'd be very hard to go through that and conclude that that was anything other than torture, even though he wasn't ever waterboarded.
So from the back, I guess, the back left? Yes, you, looking behind you. You, the woman, yeah.
All right. The National Religious Campaign Against Torture, which I work with, has been proposing a process when government wants to use an unusual, not covered by the field manual interrogation technique that they call the golden rule, which is that the president would have to sign an executive order saying that this procedure would be acceptable if used on American citizens as an interrogation technique. What do you think about this approach? Do you think it is workable?
Well, I'll start. I mean, just because we're talking about international conduct and the application of this kind of treatment of U.S. Personnel. I mean, in fact, When I said that lawyers should think about the policy implications, one of the things that's interesting about our obligations under the Torture Convention, of course, is that they are reciprocal. So whatever we say the torture memo means, presumably